Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Today I'd like to direct your attention to June 6th, 2023. And if you go to the docket in Idaho versus Koberger, you will see state's supplemental response to the release of the grand jury materials, the transcript, and other documents. You'll recall that yesterday, two notices of hearing were filed on the docket the day before, June 5th, 2023, setting for hearing the defendant's two motions seeking the release of those grand jury materials. And sometimes when a notice of hearing on a motion is set, then you see the other side coming back and either filing a response or doing as what happened here, filing supplemental response. So what a supplemental response is it supplements the prior response. It adds to it. There's more information that the prosecution here is providing to the court that the prosecution feels is relevant. The prosecution here in this supplemental response reminds the judge that in the response to the motion for the release of these materials that the state had mentioned, they put together a proposed stipulation regarding the release of these materials where both sides would have gotten together and agreed that certain materials should be released and certain shouldn't. He drew that up. He sent it to the defense, and he mentioned to the judge that the defense was looking at it. Well, he comes back now and says that unfortunately that both sides were unable to agree to a stipulation. And what's that? That's where they go to the court and they say, Judge, this is what we're hoping that you will rule in this case, that you will provide this, and this, and not this, and this as it relates to the grand jury materials. Now, there's no requirement that a judge ever has to sign and agree to a stipulation. Sometimes they don't. Sometimes they add information. Sometimes they take it away. Many times they will go ahead and enter the order granting whatever the stipulation says. But here we see that this proposed stipulation regarding the release of the grand jury materials, unfortunately, probably both sides, maybe they went back and forth a couple times based on their best efforts. They couldn't come to some agreement. He goes in, the prosecutor, in this supplemental response to talk about how important it is and that the defense may not be entitled to everything that they are seeking, and here's why. And he cites to law. He cites to the fact that under Idaho law, that grand juries are intended to be secret. So again, secret grand jury, Mr. Thompson was there. The defense wasn't. But that's how it's set up. Like it or not, that's how grand juries operate. They operate by state law, and state law in Idaho, per this 2015 case that was another death penalty case, the Idaho Supreme Court came out flat out and said grand juries are intended to be in secret. So what will happen next is that there will be a hearing on the defendant's motions. Both sides will have an opportunity to give oral argument. The defense will say why she feels, that is the attorney for Mr. Koberger, Ms. Taylor, why she feels that what she's asking for should be released. Mr. Thompson will come back and give his counter arguments, and then ultimately the judge will have to make a decision in this matter. If you'd like to take a look at this supplemental response, you can follow the link that I've provided in the description to this podcast. This is Kathy. Thank you for joining us here today. Please join us again for a future episode of the Indie Zone.